pages but have never visited the terms of use section of
Right.
Facebook. So here you're putting what you may think to be relatively personal, private information, and yet Facebook has the right to distribute it as much as they want. As long as you put it up, Facebook has the right to keep it on its servers, has the right to share it with other users. So, privacy is a complex area. And in the specific case that you mentioned regarding the DNA, the person signed a release, not fully recognizing what the release meant, what the implications of the release were, and signed away its rights to its own DNA. Now, I think the court reversed that decision and actually sided with the individual, saying, no, you possibly didn't understand what you were signing, or that you can't alienate yourself from your own physical DNA rights.
Right.
But that's not going to happen every time, and courts have to respect, contracts and businesses. And when an adult who should otherwise understand what he or she is signing away does so, and especially when there's consideration paid, a company will pay for
Tell us
certain
what
rights.
consideration is.
Consideration is payment. It could be in the form of money. It could be in the form of property. It could be in the form of services. When two contracts, as you know, Dan, when two parties are coming together, when one party receives something, they have to give up something in order for that to be an enforceable contract. What that person is giving up, we call, in the legal world, consideration.
So in just the few minutes we have, I have some specific questions that may seem tangential, but
no,
why not?
No, fire away.
I had heard that Smucker's has patented the crustless peanut butter sandwich. They actually got a patent on it. So they got a peanut butter sandwich, they cut the crust off, sent it to the patent office, maybe not that particular sandwich, but they got the patent on it.
It's sitting in the Smithsonian.
Yes.
Right now.
But moms have been doing that for ages. How can you get a patent on something that has been in our life?
So I'm not familiar about that specific case that you mentioned, but the patent office, in order to award a patent, typically has three tests, a three-prong test.
Okay.
The first is utility. Is there a good reason for this product to exist? The second is innovation. Okay. Innovation meaning, has it never existed before? And the third is novelty, non-obvious.
Right.
Right. There's lots of stuff out there that we're constantly improving upon and further developing. Is the subsequent development or improvement non-obvious? Or is it obvious? You would obviously go from step A to step B, and so why should we give somebody the rights to step B? If a particular invention passes those three tests, and there's nothing to disqualify it as being, having already been disclosed by somebody in the past, it may very well qualify for patents. But that's why getting a patent is such a long and arduous process, typically up to 24 months in this country, because the patent examiner will run those tests over and over and over again and throw the patent application back to the lawyer or back to the applicant saying, well, you haven't passed. Show me why it's non-obvious. Show me what the utilitarian aspects of the particular invention are.
Do you know if the courts who review patent challenges have any special expertise? Because if we go back to my examples, and we were talking about DNA, and we were talking about my pharmaceuticals, and all these, it seems like you have to have some science background in a few of these cases. It's not just about the law, it's about understanding the science.
It's a funny you ask that, because us intellectual property lawyers always joke how the worst jury to be a part of would be a patent infringement case, because you have two highly technical companies trying to fight over which invention is legitimate, which one has superior rights, and these all rest or live and die on details, on the most esoteric details.
And you have to be an engineer or
a
biochemist or something.
And so some construction worker, in the Bronx is having to sit for 3 weeks listening to why one printer is different than another printer.
And they're lost in opening statements.
Right. Same thing with judges. And that's why very often lawyers try to bring patent cases in jurisdictions that are more conducive, where you may have a slightly more sophisticated jury pool to choose from, and where even the judges themselves are a little bit more acquainted with patent-related issues.
We only have a minute left, and I wanted to talk about a specific case that I find fascinating. There was an Orthodox rabbi who was walking down the streets of Manhattan who had his photograph taken, and he did not want to have his picture published. He didn't know about it because he wasn't wanting to go through these books, but a photographer thought he was a great specimen, shall we say, and printed it, and there was a big court case to say, do you have a right just to be in public and be private? Or can you expect if we walk out of studio now and people say, I like that guy, I'm going to take some pictures, make a calendar of him, make some money off him? We only got a minute, so give us the short version of a very complicated answer.
The short version is that people who are not famous, people who are not regularly in the public eye, typically have a right to privacy. By putting yourself in the public eye, though, a celebrity, an athlete,
talk show guest.
Dan, you need to watch out for this. By doing that, you actually give up certain privacy rights and certain personal rights. One of the issues that we typically deal with in the context of sweepstakes, and this is not legal in every state, and states vary, is we'll put in the contest or the sweepstakes rules, we'll put a mandatory release that the winner of the sweepstakes gives up the right to have his or her photograph taken and publicized by the company that's running the sweepstakes.
Right.
Because it could just be a housewife from Oklahoma City or an accountant from Boston who has not given up those rights. The sweepstakes sponsor or the company that's running the sweepstakes wants to make sure they have the right to use that person's photograph. Same thing with lotteries. You give up that right. If you win the lottery, you win the huge jackpot, you give up that right to have your picture taken. So the shorter answer is we all have certain personal rights that are protected and upheld by the courts in most cases, but there are certain types of individuals who will lose those rights by putting themselves out in the public domain. And I guess also if it's a newsworthy point, so somebody, for example, is on trial who isn't a celebrity, who isn't a talk show host like you, but just simply being in the news also loses certain rights for the betterment of society. That people want to see that person's picture. Maybe society has a right to see that picture because it's the news.
Thank you for coming in. I greatly appreciate your expertise.
Dan.
And thank you for tuning in to Law Talk Today. I'm Dan Agatino, your host. Please tune in again.